Planning for a disabled adult child's protection while also considering navigating Medicaid asset protection for yourself can be super complicated. This can all seem very overwhelming, but this is how our team helped a couple clients sort through all the noise and create a strategy that's going to work for them. Patricia and Martin are a married couple who moved from the state of Georgia to North Carolina just in 2024, having made an estate plan back in 2005 under Georgia law. Now, that estate plan included a last will and testament and a third-party special needs trust for their son. They have two adult sons, Mitchell and Cary, and Mitchell has a disability that, at least back in 2005, they believed was appropriate to have a special needs trust to make sure that we could protect future eligibility for things like SSI and Medicaid for Mitchell. Now that they've moved to North Carolina, their primary considerations are just a global update and making sure that their best posture to protect their own assets if they were to need skilled nursing care in the future, but also make sure that Mitchell is well cared for while also considering Cary's future needs as well. Over the years, they've realized that a will plan's probably not serving them well, just from a probate avoidance and asset transition perspective. And so they've been considering a trust plan of some sort from, before they moved to North Carolina. This isn't something that came up after their move. But now that they have moved, it's brought up the consideration of what else might need to be updated. This case reflects common issues that parents who have a child with a disability, but are also concerned about their own medical needs, often struggle with, and that our firm deals with quite regularly. To start, their biggest concern was, do we need to update our estate plan now that we're no longer living in Georgia? Is the Georgia estate plan now invalid moving to North Carolina? Their intentions are to stay here, not to ever move back to Georgia. And so they're concerned that there may be a need to update things moving forward just to domesticate, right? Make sure everything is okay under North Carolina law. And it's not that everything became invalid as soon as they crossed the border. It's that their Georgia plan is from 2005, and it doesn't specifically contemplate North Carolina procedures, North Carolina laws and provisions. And so while these documents are probably still legally valid under Georgia law, they probably will still run into resistance here in North Carolina with North Carolina banks, courts, and hospital systems not being familiar with Georgia documents or having to prove the validity of these Georgia documents whenever that day should come. They're also very concerned about what would need to happen if they were to pass away in order to sell their home, in order to realize the benefit of the equity value of their house rather than just sitting on real estate in the event that they're no longer here. They were also considering the difference between will planning and trust planning and what would ultimately be the best outcome for not just themselves now, but their kids in the future. But two main challenges were really driving the ship for their estate plan. The two biggest points of consideration for Patricia and Martin were really whether we still even needed a special needs trust for Mitchell, given his current circumstances versus where they were back in 2005, and whether there was additional asset protection strategies or structures that may make more sense for them in their current posture with their current assets. And since it had been about 20 years since they did their original estate plan, we really needed to refresh their fiduciaries so that their agents now are who they actually should be now, not just who they named 20 years ago. Now, to give more context on Mitchell and the parents' assets and needs, Mitchell had been actively seeking employment, and his present and future eligibility for things like SSI and Medicaid were highly questionable. It wasn't likely that he was going to qualify for different benefits because of the amount that he was able to work. Social Security generally is based on someone's ability to work meaningfully, not that they can fully support themselves, but that they can work generally enough to make about $16,000 a year in income. It was beginning to become clear that Mitchell probably was going to be able to get a job and probably wasn't going to be able to qualify for things like SSI and Medicaid. It's a big unknown currently, though. And so given the posture, we're going to keep his special needs trust in place, which had been updated just a few years prior. So we're not reinventing the wheel. We're not starting from scratch. We're keeping a structure that they already had in place, at least for now. Over time, we can reevaluate that structure to decide whether we want to keep it, update it, or revoke it, given how Mitchell's circumstances will evolve over time, whether he does in fact get a job or does not and can qualify for SSI and Medicaid. Patricia and Martin have substantial assets. In fact, they're worth over $4 million in liquid investable net worth before we even say anything about their cash and their savings accounts, their cars, and their house. And so when we walk through the practical considerations of what it means to qualify for Medicaid for their own long-term care skilled nursing needs, it would mean they'd have to get down into the $150,000 range of total investable net worth in order to even qualify for Medicaid. That's a pretty substantial reduction in wealth, and it would also require them to want and seek Medicaid-type services rather than use their own assets to pay for their own needs. This is a pretty common scenario for clients of ours where they just think, because they've read online or watched a YouTube video, that everyone should be posturing themselves for Medicaid in the future, and that's just not the case. Some people are what we call self-insured, and they're more than capable of paying for their own care needs if they ever need them, and in the way that they want, rather than just satisfying for whatever Medicaid will pay for. Given that fact, it didn't make a ton of sense after discussing these realities with the clients to create a more aggressive, irrevocable protection trust plan for them. It would be overkill, and it was leading in a direction that they actually didn't even want to be in. Overall, it did make sense to switch from a will-based plan to a trust-based plan in their current posture. 20 years ago, the kids were very young and obviously weren't going to be playing a part in the roles that we are appointing today, like trustee and executor and the like. Now, their son Cary is going to be the one vested with so much responsibility, but he doesn't even live in the state of North Carolina. He's going to be serving from wherever he ends up living. In a will-based plan, it means that he cannot be the executor without appointing someone else to serve with him. That's called a resident process agent. No executor can serve unless they're a resident of the state of North Carolina without someone else who is a resident of North Carolina serving with them. To take a step further, by using a trust-based plan and holding their home in the name of that trust, they're able to sell that property right away without any sort of delays like probate. They're also able to allow Cary to serve as trustee from wherever he lives in the United States, whether that's back in Georgia or here in North Carolina if he eventually moves here. We're supplementing that trust with what we call pour-over wills. Those are last will and testaments that are just naming the trust as the sole beneficiary of any assets that Patricia and Martin may leave behind that didn't make their way into the trust, either through beneficiary designations or through retitling itself. That way, the trust itself controls everything. In the meantime, this new trust is going to name Mitchell's Special Needs Trust for whatever benefit should go directly to Mitchell. Because it's not going directly to Mitchell, it will still be protective of his interests and won't preclude him from getting SSI or Medicaid in the future for being over the resource caps. But we're also going to let Cary control things as trustee, protect the assets for himself and for his brother, and make sure that everything is being cared for and coordinated right away without having to go through probate. Patricia and Martin will also get powers of attorney for financial and healthcare purposes. They're able to select somebody like Cary to be able to make their medical and financial decisions and pay their bills in the event of any incapacity, instead of having to go to the court and get guardianship over themselves to be able to have that authority to act. This is all a very comprehensive strategy that takes into consideration their actual needs, the practical impact of different planning decisions, and what the future could have in store for them. But by knowing more about their goals, their current scenario, where they were and where they want to go, we can create a strategy, implement it appropriately, and make sure that everyone is getting exactly what they're supposed to in an efficient way, very organized, and ultimately accomplish their goals without delay.
It's time to take control of your legacy. Click the link below to start the process.